So, good morning, students, and welcome again to our third lecture on international law. We have already dealt with sources of international law, and that was what we treated last week, and we also treated subjects of international law. So today we are going to treat treaties. Remember what we talked about last week, that a treaty is the major source of international law. Okay? Now, today we are going to talk about this treaty, what is treaty, how are treaties enacted, and so on and so forth. So, today is the day to know what treaty is all about. Most of the time, we hear a lot of words like convention, exchange of notes, memorandum of understanding, covenants, charters, things like this. All these are various names given to treaties under international law. Okay? So whenever you hear about convention, you know they are talking about treaty. Whenever you hear of exchange of notes, mostly diplomats are used to this one, you know they are talking about treaty. Whenever you hear about memorandum of understanding, you know it has to do with treaty. Or whenever they talk about covenant or charter, like the United Nations Charter, you know it is all about treaty. It is a different name given to what we now know as treaties. Okay? All of them are governed by the Vienna Convention on the Law of Treaties of 1969. Okay? Any question? Now, the only true binding instrument of international law, as I told you last week, is treaties or conventions or exchange of notes or memorandum of understanding or covenant or charter, etc. They could give it any name they want, but as far as international law is concerned, these things are the only true binding instrument of international law. I told you guys why it is the only true source of international law. Can anyone tell me? No one? Now remember I told you what they call pacta sunt servanda. That is the principle guiding treaties. It means in English, agreement is agreement and has to be respected. That is why when countries, presidents or prime ministers, when they sign any treaty, they have to keep to it because of this principle of pacta sunt servanda. Okay? Now, secondly, there are concluded between equals who express their will to be bound by these treaties. Remember, international law is what we also talked about, jus gentium, which means law of the land, which means it is mostly between states and states. So every sovereign state is equal to each other, and once they come together and decide to sign a treaty, everybody under every state under international law are equal, and that treaty they sign are binding to all of them, regardless of your status as a powerful nation or not. I know you are going to ask me a question, but why is America or Russia not following treaties, blah, blah, blah? We talk about that in another topic, but we know this has always been the problem with international law, because big country or strong country, they usually don't respect the treaties. However, if you violate any treaty signed, the consequence is there that you will pay, even if you're a big nation or a powerful nation or not. You must pay for violating your the terms of the treaty that you violated. Okay. Thirdly, commitments taken by states in the forms of treaty are stronger than customary law. We already know what customary law is, although we say that international law, one of the sources of international law, is also customary law based on practices and opinion juris. Yes, that is true. So, but treaty is stronger than customary law under international law, because treaties are signed by your president or your prime minister or your diplomat, and because of that signature on it, that makes it binding. Customary law is not mostly binding. It has to meet a lot of conditions before it becomes accepted by all nations. Okay? The fourth one is that it is more difficult for a state to leave the treaty than to change the custom. Okay? Also, agreements between states and individuals, that is private entity, are not part of international law. Just like I've already said before, international law is jus gentium. It is the law of the state, so individuals has no business there, unless when your fundamental right is breached. That is the only way individuals were kind of or partially included in international law, so that their human rights would be safeguarded by their states. So, and also the effect of treaty could be one, there has to be a clear obligation. It must be binding upon the signatures of the parties, and failure to fulfill obligations leads to international responsibility. I told you guys already that eventually in this course, we are going to talk of law of responsibility under international law. So when we get to that lecture, you will understand also the failures and consequences if a country breaches the terms of treaty. Okay? Now, we already said that the Vienna Convention treaties are governed by the Vienna Conventions of 1969. Now, let us understand what this Vienna Convention of 1969 is. Vienna Convention on the Law of Treaties was adopted in 1969. It entered into force in 1980, and during that period in 1980, only 112 states ratified it. 15 states signed but not ratified it. States like Afghanistan, Bolivia, Cambodia, El Salvador, Ethiopia, Ghana, Iran, Ivory Coast, Kenya, Madagascar, Nepal, Pakistan, Trinidad, and Tobago, United States, of course, and Zambia. You know why America, of all people, the founder of this, what we call the liberal democracy, did not ratify the Vienna Convention. That is a topic for another day. Okay? But these 15 states signed the Vienna Convention but did not ratify it. Okay? Other states ratified it. Also, it is main document that sets out rules for creation of treaties. It covers only relations between states, like we said, use gentile. Okay? There is analogous convention for international organizations that was adopted or ratified eventually, sometimes in 1986. Okay? Now, under international law, we have what we call jus cogens. Now, what is jus cogens? Jus cogens, for example, a constraining law or preemptory norms recognized by all states. That is called jus cogens. It can also be elementary rules that concerns the safeguarding of peace, prohibition, recourse to force, or the threat of force. It could also be norms of humanitarian nature, such as prohibition against genocide or slavery, or racial discrimination. So, any laws that concerns all this, or any treaties that concern all these crimes that I mentioned, are called jus cogens. They are preemptory norms and they are compulsory. You cannot breach them. Okay? Article 50, I think Article 53 of the Vienna Convention states that a treaty is void if, at the time of its conclusion, it conflicts with preemptory norms of general international law. For the purpose of the present convention, a preemptory norm of general international law is a norm accepted and recognized by international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by subsequent norms of general international law having the same character. So when this Article 53 defined precisely without ambiguous words what jus cogens is all about. If you are not clear about what is jus cogens, let me repeat again Article 53 of the 1969 Vienna Convention on the Law of Treaties, how it defines jus cogens. It says that a treaty or any treaty is void if at the time of its conclusion it conflicts with a preemptory norm of general international law, okay, for the purpose of the present convention. A peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norms of general law having the same character. So students, this definition is very important because in your exams, your lecturer might decide to test your understanding of international law and then ask you, define what jus cogens is. That is why you have to listen to this, my definition. You have to memorize it because most of the time it comes out in your exam and you will give examples after defining it. Okay? Now, we are still talking about treaties. We say that treaties involves parties or states. It cannot be one person now, so it has to be two or more states coming together, deciding that they want to do this, and those are the people that they call parties to the treaties. Now, a state, on behalf of states, may act only authorized persons. Mostly the sectoral treaty are signed by ministers of governments, or general treaties are signed by president or prime minister or the monarch, if they have monarch like queen or king. But most of the time, the queen or king will delegate the power to the prime minister to sign on his or her behalf, because as we know, under international law, kings or queens are usually a ceremonial position. They are not involved in government. That is why they appoint a prime minister to represent them. That is why most of the in those days, especially when monarchy is still rampant, they use what we call parliamentary system, especially in those days. But now they only have few monarchs in the world now, and still they practice parliamentary system. Most governmental functions of the queen or king are performed by the prime minister. Okay, now also agency for the states is almost not qualified to sign treaties on behalf of the state. Example, Felipe Bano, Varela agents of the government of Panama in the case between U.S. and the Panama negotiation on the Suez Canal. That case, we will eventually talk about it because the international court somehow accepted that this agency was... Anyway, we talk about this case later as we proceed in this international law. So we already understand that in signing treaties, the people that are authorized to sign the treaties, at least it has to be the prime minister or the president or anybody who has received authority from the president or from the prime minister to do that on his behalf. Most of the time, ambassadors get this power of attorney from their president or from their prime minister to sign a treaty on their behalf. Okay? So, concluding this law of treaty, the important moments we have to remember whenever we are talking about treaties are: one, signature. It concludes negotiation on the text. Secondly, it is done by proper seat official or agent. In other words, when the president is not there, when the prime minister is not there, whoever is there will show power of attorney from the president or from the prime minister before he or she would be allowed to be the authentic representative of such government or such states. Okay? Second thing we consider important is ratification of that treaty. In ratification, internal acceptance and confirmation. Secondly, there has to be internal procedure, usually consent of the parliament or a referendum. Before government signs a treaty, they must have internally discussed it with the parliament, get approval of the parliament before they proceed further. In some other states too, it is possible to conduct a referendum from the people to see what the people thinks before the government will go ahead to signing such treaty. Okay? Now, ratification signature is always confirmed of the states that the necessity or the necessary procedures happened during ratification. Also, in some states, has the ratification significant effect for the internal force of the treaty. That is why ratification is very important in any treaty. Okay? Now, the last thing that is very important when it comes to treaties is: when will this treaty take effect? Okay? Or when will this treaty enter into force? This depends on the content of the treaty and the treaty provision. It must be inside that treaty when it has to take effect after the signature of the whoever is in charge of the signature, and then when that date comes, the treaty becomes official and binding, and the principle of pacta sunt servanda takes effect immediately. These procedures are carried out. Okay? If there is no provision, however, on when the treaty will take effect, then treaty enters into force after the last party ratifies it. Okay? Some treaties are open because most of the parties, especially treaties that a lot of people a lot of states are involved in, because of bureaucratic issues, these states might not yet be ready to sign it yet, so it delays. So some treaties are like that there will not be a set date for when it will take effect. They will just leave it until the last person or last state signs and ratifies the treaty, then it becomes effective. Okay? So, reservations. This is usually experienced when a big power is involved in treaty ratifications or in treaties, they always reserve for whatever reason, they put their reservation on the contents of the treaty, and it's it always happens in treaties. So reservation is what we have to also watch out for in treaty ratification or treaty signing, because unilateral out of state, I mean, when people want to know, but what is this reservation? Then the reservation means a unilateral act of state by which a state refuses certain part of the treaty, like America refusing to ratify the International Criminal Court, and they made their reservation. I think their reservation was that American soldiers cannot be charged for any war crime or something like that. And because of that, up to today, America refused to recognize International Criminal Court, and no American soldier would be tried in The Hague for war crime committed in their mission abroad, because America had reservation on the treaty forming this International Criminal Court. And also, the treaty provides that only specified reservations, which do not include the reservation in question, may be made. Again, the reservation is incompatible with the object and purpose of the treaty. So when whatever reservation you are making is incompatible with the object and purpose of the treaty, it is mostly not to be accepted by the parties. Okay? Now, interpretation. How do we interpret treaties? Treaties has to be interpreted, one, by a basic principle. A treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the term of the treaty in their context and in the light of its object and purpose. Also, there is a full system of interpretation rules in the 1969 Vienna Convention. Okay? Now, we also have treaties that are considered invalid and null and void. What kind of treaties is this? One, if there is good faith missing by one of the parties, or the internal procedure has been affected by fraud, it is ground for invalidity of a treaty. Also, lion treaties are forbidden and also conflict with Uskogun's treaty. Any treaty that conflicts with Uskogun's principles are also forbidden or considered invalid. Now, when are treaties normally released? Now, treaties are either released by time expiration, or by withdrawal, or by decrease of numbers of the parties under certain number, or by replacement of that treaty. Okay? Collection. In order to make treaties known to the public, there has to be a publication of it. The treaties are usually published and collected by a chosen party or mostly by United Nations, because, as we said, treaties are usually jus gentium, and everything has to be decided at the United Nations, and then before the parties, the countries start signing. That is why treaties are published by the United Nations or by any other chosen party. Okay, so this is all about treaty, and you can read about the 1969 Vienna Convention on the Law of Treaties, and that is going to help you more. Students, we have issue also. Most of the time, these lectures are abridged, published on Facebook, so you don't get the details till this stage. So what you do is, if that is the situation with Facebook, you can always find the detailed version of it on YouTube. That is where you have a detailed publication of this lecture. And we are trying our best to see that we keep to Facebook policy and not violate them to avoid problems. So if you only get reel of this lecture on Facebook, no worries, go to YouTube and you will find the detailed version of it. While uploading the reel, of course, we are going to give you the YouTube link. You go there, take your time, listen to it. All our goal here is to make sure you get your A's or B's in this your law courses in international law, European law, in your bachelor stage or master's stage. Until then, I wish you guys a happy holidays as we are going in for some winter break, and we meet you in our next lecture in 2 or 3 weeks' time. Enjoy your vacation and see you guys soon. Bye.